Morning, everybody. Today we are finishing with the OTP. I'm doing from clause 14 until the end. So hopefully we'll finish quickly, but let's just get through the rest. Breach I always leave as a clause to be discussed first in the session because there are often people that don't understand exactly what it means. Now, a breach of a contract, it means that if you promised something and you didn't deliver. It basically means failing to deliver according to the terms of a contract. It doesn't mean that you don't get a bond, that's a condition. It's not a terms, it's a condition that you put in the contract. And if you put in, for instance, that the door has to be fixed, it's not fixed, then that would be a condition that's not met. But it's the terms of the contract. We are referring to clauses in the contract where we put in timelines that we don't stick to, or that the client, the seller or the buyer that didn't abide by. So I just want to read it quickly. Should either party commit a breach of any of the terms of this agreement and fail to remedy same within 7 days of being called upon in writing to do so, the conveyancer does this, the aggrieved party shall be entitled to, without prejudice to his rights, claim any damages that he may have suffered as a result of such a breach, to cancel the agreement by written notice to the defaulting party, or to claim specific performance by the party in his obligations in terms of the agreement. So it doesn't mean it has to be cancelled. The one party can decide, the one that's suffering can decide whether he wants to cancel it, or whether he wants to claim specific performances, or whatever the case may be, or claim damages. No latitude, extension of time, or indulgence granted by either party to the other shall be construed as prejudicing such party's right to insist on the strict and punctual compliance by the other party with the terms of his agreement. Means you can't take it lightly. All the clauses have to be taken seriously. So, and that everybody has to stick to their commitments. Should this agreement be cancelled as a result of breach by the purchaser, then the purchaser acknowledges and irrevocably agrees that his deposit and any amount paid to him by him to the conveyancer for costs in connection with the transaction may be utilized towards payment of a professional fee and may be paid out to Property.CoZa by the conveyancer from such deposit or costs received. So we stand first in line here. Once, if somebody breaches, then we can still claim our commission from money that's already on the file. Property.CoZa, the seller and purchaser hereby indemnify the conveyancer against any claims or damages or otherwise that may be instituted by any part of this deed of sale for any reason of payment of a professional fee made by the conveyancer to the Property.CoZa in accordance with this paragraph. So in other words, they can't hold the conveyancer liable because in the contract, he's not part of the damages. So this is just to make safeguard the conveyancer. Any balance shall be paid to the seller as liquidated damages. So they first take off our commission and then they pay the seller the rest because the rest is damages to the seller. But first our commission gets paid. Upon cancellation of this agreement, for any reason whatsoever, the purchaser hereby undertakes to vacate the property within 24 hours and to ensure that the property shall be vacated by any person who occupied through the purchaser's title or by his permission. Occupation shall be redelivered in the same good order and condition as at the occupation date. So if they moved in, the breach and the transaction for no other reason doesn't carry on, then they have to leave the property within 24 hours. The defaulting party shall pay all legal and other costs, including costs on the attorney and client scale, incurred by the innocent party in successfully enforcing the provisions of this agreement. So the person that defaulted is liable for the costs. The purchaser and seller choose their addresses as stated in this agreement on our annexures. They will accept delivery of service for all notices and legal processes. Nowadays, they also accept email as long as they can prove that the email was delivered to the right person. All notice required to be given by one party to the other shall be in writing and shall be deemed to be received by the addresses on the fourth business day following the posting thereof by prepaid registered post or on the date of delivery of transmission of if delivered by hand or if transmitted by fax or sent by email. It's covered. Somebody's sound is on. Anyway, it's better now. Okay. The moral clause. I don't know whether everybody understands what the moral clause means. It means that the one party, if it delays it unnecessarily, if it delays a contract, there is a penalty payable. This is a very good clause to use to scare people to quickly deliver. So in the event of there being any delay by either party, or which delay has not been agreed upon in writing by both parties, the defaulting party undertakes to pay interest on the purchase price over and above the occupational rental due. So it's not the occupational rental, it's another penalty, over and above. The agreed interest rate shall be 2 percentage points above the prime lending rate charged by Nedbank, to be calculated from the date the defaulting party is notified in writing by the conveyancer as being in mora to the date on which the defaulting party has ceased to be in mora. So this is a lot of money. If you think our interest rate is 9.75, so 11.75 on the purchase price, they will pro rata pay. They'll be liable for that. So that's a very nice clause to scare people off, not to tell them to please deliver when they have to do, when they have to according to the timeline. But just remember, it's also very vague in terms of when are they in mora. So between yourselves and the parties involved and the attorney, we have to decide. Sometimes they keep on saying that they don't have a car, they don't have petrol to go and sign, or somebody's sick, or whatever the case might be. One will have to go back onto the timeline of all the emails to make sure that the person is in mora before we suggest this. So we can't just put them on mora when we think it's long enough. We have to look at the timelines and make sure that we are outside our timelines. Company or close corporation, should the purchaser act as trustee for a company still to be formed, and the said company is not formed within 21 days from date of the signature of this agreement, or if it is formed, but the agreement is not ratified and adopted within 21 days from date of signature of this agreement, the purchaser, in his personal capacity, shall be the purchaser hereunder and shall be bound by all terms of this agreement. So he can't then walk away and say the company wasn't formed because he assumes liability in his personal capacity. Should the company be duly formed and duly adopts and ratifies this agreement, then the signatory, by attesting his signature hereto, binds himself as surety and co-principal debtor jointly and severally, it means independently and together, with the company for the fulfillment of all the terms and conditions of this agreement. In the event of a registered company, trust or close corporation being the purchaser, the signatory, by attesting his signature hereto, binds himself as surety and co-principal debtor jointly and severally with the company, trust or close corporation for the fulfillment of all terms and conditions of this agreement. Make sure you understand that. Just also remember, you can never have a trust to be formed, as I said in a previous session. You can't say trust to be formed because they have to have a T number or IT number already. This is a sectional title contract that I'm using. The purchaser acknowledges that he is required to become a member of the body corporate and or home association of the complex as stated in paragraph 1.15, and that he will be bound to its rules upon registration of the transfer. At this point, I just want to point out to you that body corporate is normally the body that in a sectional title, and HOA normally in a full title, but some complexes do just call their body corporate or home owners association. But HOA is normally applicable to full title complex where it's clusters. The monthly levy in the account stated in paragraph 1.16 and the subject to an annual escalation is payable from date of registration to the body corporate or HOA or its managing agents. So it's part of the deal is that they have to start paying the levies. The purchaser acknowledges that he has inspected the financial statements of the said body corporate or the HOA, and that he is satisfied with the contents thereof. Sometimes you'll find that the banks also, before they approve, ask for the financial statements. It's very good practice to get that already. We ask for that when you do a listing, because the owners can get it easier than we can. We don't want to ask money for us if we want to get it, but it's a very good practice to have that ready and also part of the documentation that you give to the buyer. The purchaser acknowledges that he has inspected the management rules of the body corporate and the HOA and is satisfied with the contents and is aware that by completing this offer to purchase, he's binding himself legally here too. Now, I think Tina said in the previous session as well that please see that you get those rules, get it signed up front so you can give it to the attorney. It makes it so much easier for the attorney. Then they don't have to collect it from the managing agent and have it signed when they do the documents. They receive it and it's all done. It's done and dusted, and then they can just proceed. The fixtures and fittings, this should be transferred from your listing card. Everything that you have in your listing card must come in here. You must make sure that you do it correctly. The owner doesn't have to do this. This is not our annexure A. Our annexure A has to be done by the owner. This one can be done by you as long as the buyer and the seller ratifies it. They see that everything is correct. There's space there for something extra, and you just stick in there. I'm not going to go through the list. And then if you specially exclude something, it comes in here. If there's nothing to be excluded, just put NA. The seller warrants that all fixtures and fittings are this property and are perfectly paid for. Because sometimes they bought something on an account that they're paying it off, and then they just leave it there, and then who's going to pay for it? So here he has to warrant that it's all paid for. The seller undertakes to maintain the property, fixtures and fittings in the same good condition and working order from date of signature of the offer to the purchaser to date of transfer. Again, your photos will help. Let's say the pool was nice and clean and blue when you took the photos initially, and when the guys move in, then it's green. Then obviously the seller is liable to have it fixed. But make sure that you use your photos. Now, this one here is actually a total session by itself about the alien and invasive species. The aliens aren't people from Mars. It means species or plants that aren't South African. So in terms of the National Environmental Management Biodiversity Act, the seller here declares that to the best of his knowledge, there are no invasive alien species as per the National Register of Alien and Listed Invasive Species present on the property. You can Google that, you'll see the different categories, but everything as alien falls under this clause. In terms of the National Environment Management Biodiversity Act, the seller declares that the following listed alien invasive species are present on the property. So if he knows of anything, for instance, let's say there's a blue gum tree, which is actually an alien. They must just put it in here. The purchaser understands that he must apply for a permit with regards to the category 2 alien invasive species in his own name in terms of this act once the property has been transferred. The purchaser acknowledges that he has acquainted himself with the extent and nature of the property and accepts the property as such, including the vegetation on the property. Now, this can be very involved, but in a normal South African household, it's not that bad. Normally, it's just in everything, but it's just we have to have it in our offer to purchase. Special conditions, we've done that already. Remember, if there's no special conditions, put NA. If there are special conditions, be very clear about what has to be done, who's paying for it, and by when, and who's doing it. Be very clear as to what you put in here, and put NA at the end. This right to extend is also a whole session by itself. In short, it means that in schemes, in sectional title schemes, that there is a Section 25 Act that actually applies to it. That was brought in a couple of years ago. It wasn't always like that. It was brought in for places. I'm going to give you an example, like in Hillbrow. In Hillbrow, I saw a block of flats, and it had a lot of parking bays under carports. And then 2 years later, this block of flats and the carports were actually extended in that where the carports were, they built more flats and they put more parking on top of the flats so that they had the certain amount of parking still available as necessary for the sectional title register, but they used the extra space in the complex to build more flats. So this is basically just says that you can extend on a scheme if there is space. So let's say I also saw a complex in Bloemfontein where there were tennis courts and the tennis courts weren't used. So they were looking at extending the complex by putting more units there. But you must, as I said, it's a whole session by itself. But as long as you know, it's just that you sit so that the clients know that there is a right to real extent to extend this to extend the scheme in terms of the Section 25 of the Section Titles Act. You can read it up if you like, but as long as you know, it's just to allow for that. Processing of personal information, that's papaya. That's what the day before yesterday, that those of you that attended the Lightstone seminar would be very, very fresh in your minds. The purchasers and sellers consent to and authorize Property.CoZa to conduct, request and verify personal information from the FICA requirements from third parties that it may deem to comply with the purpose of FICA. Remember, this lady also spoke about purpose the whole time in that seminar. So let's say I get the FICA from the buyer and the seller, I may disclose it to the attorneys, which is the third party. So I can share it with them because over here the clients give their consent. The purchasers and sellers hereby give consent to Property.CoZa in the capacity of the estate agents to the contract to process their personal information to facilitate the sale of the immovable property. The parties to this agreement consent to that the personal information may be shared only with the relevant conveyancer as stipulated in clause 55. It doesn't mean you're allowed to share it with anybody else. You can only share it with the conveyancer. And obviously also when we get to the financial part, we know the financial bond originator normally asks for the figure as well. The parties agree that the Property.CoZa privacy statement forms an integral part of this agreement and therefore shall be binding to this agreement. By providing your initials, you agree and consent that Property.CoZa may process your personal information in line with clauses 22.1 and 22.3. Remember on page 9, there are two places to be initialed. Over here, that is to say that you've read and understood that clause, and at the end, it's just your normal initials that you do at the bottom of each page. Cooling off clause. Cooling off clause is only for properties less than 250,000 Rand. We don't often find that. However, you do still in some rural areas find flats or small pieces of AH that you can sell for that. So under that, there is a 5 days cooling off clause as set out in Section 28(9)(a) of the Alienation of Land Act. This is not the Consumer Protection Act. That's something completely different. This is a very old one from the Alienation of Land Act, which you did in your NK 4. The parties agreed that law of South Africa shall apply to the contract and legal consequences thereof. The expiry is important to always know that there is an expiry date to an agreement. The first signature of this agreement shall constitute an irrevocable offer by the signatory, which may not be withdrawn prior to presentation to the seller or the purchaser. Sometimes you sign an offer and the client phones you that night. He says, I don't want to carry on. So legally, you must present it. In practice, it often happens that we just let the people go because we know they're not going to cooperate, but legally, if you look at it technically, we must present to the seller, whichever the case may be, and which thereafter shall remain open for acceptance until the expiry date as set out in paragraph 1.18, whereafter it shall lapse and be of no further force and effect. So if you don't present it in time and the seller doesn't accept in time, then it's not valid. So make sure you allow enough time, if you know what the availability is of the seller, for them to accept. but is binding upon acceptance thereof by or on behalf of the seller without the purchaser having been notified of the seller's acceptance. You also, once the seller has acknowledged and accepted the offer, you don't, if the purchaser wasn't found right away, it doesn't mean anything. That it's not dangerous for the contract, but it's just good practice to let the purchaser know. Property.CoZa is hereby appointed as the agent for the seller and the purchaser for the purpose of the communication of acceptance. It's just professional. Signature and counterparts agreement may be signed in separate counterparts in whichever electronic form, each of which shall be deemed to be original and of which, taken together, shall constitute one of the same documents and be regarded as an original. This answers one of the questions we had from Tennis the other day. He asked me if a client is divorced, whether they must be in the same room when they sign. They don't have to be. It can be different days, different rooms. I'm not going to go through this. We did this in our first session. I'm not going to go through any of the rest of the documentation. I just want to stop share this with you, and then I just want to speak to you quickly about the cover sheet. There is a cover sheet which the agents or sometimes don't fill in. We have to put it on Treasure Map when we load our transactions. So make sure you fill in your cover sheet and it's signed off by your sales manager. Check with your sales manager, because that will help us with the loading of the transaction on Treasure Map. The sales managers then at that point also then do a commission sheet, which is you need a higher grade. I think, Dan, you will agree, high grade degree, I don't know what, or master's degree in Excel to be able to understand that. But I think once you've got it under control, you know what you're doing.